Good afternoon. Thank you for joining me again. We live. I see there is a question that came in already while we were playing the ad. And before I start with this webinar, just a kind reminder, our free Zoom webinar taking place on Saturday. So thank you for that, and I hope you register while we are dealing with this topic today. The topic: does having a very good lawyer guarantee that I win my case? Interesting topic, something which I deal with on a regular basis, um, especially when it comes to an individual who has a strong case and is bullied by the other side. Not necessarily by the other side's lawyer, but by the other side, because the other side has money, can afford legal representation. You have a strong case, however, you cannot afford legal representation. Therefore, the question is a bit flamboyant, it's direct. I'm certain you can answer the question, but it says, does having a very good lawyer guarantee that I win my case automatically? Meaning you can have a weak case, your case can have no salt in it, no merit in it, but because I have a top lawyer, I'm paying top buck for it, I will automatically win my case. Okay, the short answer would obviously be no. Each case is different, and your case will obviously be determined based upon the merits of your case. Having a good lawyer, someone who's willing to fight for you, someone who's willing to put the energy and effort into your case, present your case, would obviously mean you will get a better result as opposed to a lawyer who is nonchalant and only going through the motions. For example, consulting with you, okay, the hour is up, let me bill you, going to court for you, I've appeared in court, thank you, here's my invoice, and so on. Therefore, the answer, in short, no. However, having a good lawyer obviously guarantees that you will get the best possible result under the circumstances. But at the same time, I need to caution, or I need to put it out there, if you do not have legal representation, or you do not have the best of lawyers out there, the case will obviously be determined based upon the merits. If you are representing yourself, make an effort, apply your mind, ensure that you watch these videos, go online, empower yourself so that you can present a positive case. I'll use a simple example. In a child maintenance matter, if the child's expenditure for the month, including everything, accommodation, food, clothing, education, and so on, is 100 Rand per month, I'm using silly figures, it is impossible for the other party, despite them having the best lawyer under the sun, to obtain a maintenance order against you for the amount of 1,000 Rand, seeing that you are earning 200 Rand per month. It will not happen no matter how good the lawyer is. The facts are the facts. However, it will be your duty to present to the court and show to the court that I only earn 200 Rand per month. And it will be your duty and your job to bring to the court's attention that a child does not cost 1,000 Rand per month. The child only costs 20 Rand based upon our example. So that's where I'm going to with this. I have a question, a live question. If you specifically have a question you want to pose to me, please make use of the Advocate Muhammad Abduroaf Facebook page. That's the page I am looking at present. and I shall deal with whatever questions come my way there. The first question, it goes as follows. I am in the process of divorcing my husband. We are married out of community of property and he is very wealthy. I can no longer afford a lawyer and he can afford the best of lawyers. I had previous lawyers who applied for a contribution towards legal cost in a Rule 43 application. Those funds have been used up and I do not have money to make another Rule 43 application. Will my husband get what he wants in court due to having an expensive lawyer? He wants primary care of the minor children but never looked after them, please advise. So how do I unpack this? In summarizing the facts simply, basically here a wife wants to divorce her husband. It's taking a bit long, it seems to me that. She did not have much money for legal fees. She made use of the Rule 43 procedure whereby she approached the court and asked the court that he contribute something towards her legal costs. And the court made an order, but however, as litigation goes, the money was used up very quickly. The father wants primary care, but he never looked after the kids. On the merits part, the father doesn't have much merits to win the ultimate case. Based upon the facts, clearly, the father should not obtain primary care because he never cared for the kids. I'm not bringing any other facts in here because there aren't any other facts. I'm dealing with the facts before me. The parties are married out of communal property, therefore her money is her money, his money is his money, so she does not have access to his money really, other than a Rule 43 application which she done. She obtained money, however it did not work out so well because the money was used up for other legal stuff. She wants to make another Rule 43 application, but however she doesn't have money for that and does not have legal fees. On the merits to the specific question, clearly you have a strong case. Despite the father having good lawyers, the fathers will still have to prove to the court that it would be in the minor children's best interest for him to have primary care, despite him never having primary care in the past, and despite you being the primary caregiver. You stipulated differently. I strongly feel he will lose his case. However, it is up to you to present your case and explain to the court that you are the primary caregiver, despite him having a good lawyer. His lawyer will obviously try to convince the court that the father can care for the minor child, or they will present evidence or facts to that, showing that the father has a potential maybe to look after the minor kids better than the mother. However, it will be very difficult for them to prove that. Therefore, ma'am, stick to your guns, prepare yourself. Do not be intimidated by the other side with the expensive lawyer, as you stipulated. Present your case, don't rush it. The court will give the other lawyer, the other side, some time to present their case, and you will have exactly or more time to do the same. I hope that answers your question, and it confirms our scenario topic. Does having a very good lawyer guarantee that I will win my case? No. Or is it I shall win my case? Question 2. I earn a reasonable salary. With COVID-19, I had to take a pay cut. My wife is claiming maintenance from me, which amount is more than what I earn. She has a lawyer and I cannot afford one. She earns more than me. Will the court grant her the maintenance she wants, seeing that I do not have a lawyer? Typical question, a question I receive often. I sometimes find it hard to believe I receive it so often because logically, having an expensive lawyer does not mean you will win your case. It will advantage you in the sense of your case will be presented very well. Nonetheless, on the facts, if the mother or your wife here, there's no mention about minor kids. I'll presume it is for minor kids. I doubt it is for personal maintenance. But if the mother wants to claim maintenance from you more than what you earn, that's a bit illogical. It doesn't make logical sense. And seeing that the mother earns more than you. So on the merits and on the facts, clearly the mother does not have a strong case. And you need to present that case to the court that's dealing with a specific matter. You need to show the court, this is my income. This, for the last 2 years, I've been earning so much money. I've earned until March 2019, before COVID-19 locked the country down. I earned so much money. And then, continuing a few months later, my salary got cut down, and this is my earnings. I use my money for X, Y, and Z, and here is proof thereof. Then you go on the minor child, to the minor child. You show the court the minor child costs only so much money. It does not cost more than what I earn. When I was with the mother, we spend the following. The child is 5 years old. The child only has school fees, creche fees, food, clothing, not much expenditure compared to a 17-year-old child. All facts are different, of course, but you're presenting your case. The mother must come with a different argument. And despite the mother having a good lawyer, which will do his job, you need to do your job as well, and you need to present that information to the court. The court will obviously know that you are representing yourself, and they will be mindful of the manner in which you present it. If somebody has a PC, a computer, you'll type the documentation out nice. You make use of Excel. If you're a layperson, you obviously have to use a ruler and some pen and paper. I hope that answers your question, and I have another live question. Let me deal with that. What must I do if baby daddy don't want to buy the clothes for the kids? The quick answer would be that you need to approach the maintenance court ASAP, and the maintenance court will make a maintenance order. The court will look at your circumstances, the father's circumstances, the child's expenditure, and come to an order. So if he does not want to pay, approach the court, and the court will deal with him. If he cannot afford to pay, and then we can look at his parents. Maybe his parents have some money and can pay the child maintenance. But don't leave it as such. Therefore, I repeat, my answer is go to the maintenance court as soon as possible. Either where you reside. Generally, I'll advise clients go to your nearest police station and ask them where is a maintenance court. Sometimes there's two scenarios, two possibilities, or where you work. Approach that maintenance court. The laws have changed, allowing for that. I hope I answered that question adequately. If I have not, you have a few moments to type in additional comments. Nonetheless, I hope I dealt with the topic today. Please note, the commenter says the following. We have additional comment on that comment. Thank you for that. It says the following. You lodge a maintenance claim at the maintenance court. Yes, that is correct. Thank you for that. And I appreciate the engagement of people watching this video, that we can assist each other. Remember, I'm a legal expert, a family law expert. However, I do not know everything, and I need to keep my ears on the ground. And the only way I can do that is to communicate with the public like yourselves, and you can advise and assist me. I hope to see you all Saturday online.